Federal Trade Court ruling against President Trump's new global tariffs. Megan Casella joins us this morning now from Washington as well to discuss what's just happened. Good morning.
Good morning, Andrew. A setback here for President Trump's tariff agenda. The Court of International Trade ruling late on Thursday that the 10% across-the-board tariffs are unlawful. So remember, these were essentially President Trump's replacement tariffs. He imposed these only after the Supreme Court invalidated the IEEPA tariffs in February. So the president used what's known here as Section 122. It allows for tariffs to address for balance of payments issues. The White House had argued in court that that meant that they could be used to address the trade deficit. The Court of International Trade, though, in a 2-1 ruling saying that the statute does not give President Trump that authority.
Adam here, and trust me, you'll want to sit down for this one. Trump reportedly erupted in fury when the Supreme Court rejected his request to freeze billions in funds, undercutting his tariff strategy and calling the decision a disgrace. The reaction reveals the gap between his image as an all-powerful dealmaker and the reality that even a court he helped shape will not rubber stamp his claims. The scene itself is remarkable. According to reporting that commentators described at the time, Trump learned about the Supreme Court's decision during a breakfast meeting with governors. That is a significant setting. He was in the middle of a formal executive function, hosting the governors of states, conducting official White House business when the news arrived. And his reaction, according to the reporting, was immediate and volcanic. He called the ruling a disgrace. He attacked the courts in terms described as explosive and vulgar. He erupted in anger in a way that was visible to the governors who were present and that was reported by people familiar with what happened in that room.
Ryan, among President Trump's first words, deeply disappointing. Talk to us about his reaction in the room and what you asked him about.
Yeah, I think there's a couple of ways to look at this, Clay. First, how emphatic he was hammering the Supreme Court in a very direct and sometimes personal way, going after a group of Supreme Court justices that he appointed, saying at one point that their families should be ashamed over this decision. He stopped short of saying that he regretted appointing them to the Supreme Court. But I do think that we need to put that into context. It is not common for a president of the United States to be so personally critical of a Supreme Court justice or a group of Supreme Court justices after a ruling. And that was at least part of the message that the president was trying to make here today in the briefing room. But then to your second point about the other avenues he has to employ tariffs. Obviously, there are these other provisions within the law that Laura outlined that they're going to try to attack. That seems to be his first and probably most reliable path forward.
That specific reaction, the public display of fury directed at an adverse judicial decision in front of an audience of state governors, is a pattern we have seen repeatedly throughout Trump's legal battles. Courts rule against him, and he attacks them personally and publicly. And the attacks on courts from a president who is supposed to respect and implement their rulings are themselves significant, not just as political behavior, but as evidence of the specific relationship between this presidency and the judicial, institutions that are supposed to check executive power. The fury at the breakfast meeting is not just a personal reaction. It is a window into how this administration processes judicial checks on its authority. Now, let us be precise about what the ruling actually did and why it matters. Because the nuclear move and collapsing presidency framing needs to be grounded in the specific legal reality of what the court decided.
Now to your money, as promised. This morning, the Supreme Court ruled that President Trump's sweeping global tariffs are illegal and must end, blowing a huge hole in his signature plan to bring back business to the United States. But $175 billion is about what the U.S. had already collected while those tariffs were in effect. That set off a rush of people looking for potential tariff refunds. And then just a short time ago, the president pledged to keep the tariffs in place using a different legal basis. So we have two reports on this tonight, starting with our chief legal correspondent, Jan Crawford. Jan, good evening.
Tony, I think we can say this is one of the most significant Supreme Court losses for a U.S. president in modern history. I mean, the justices invalidating a key part of President Trump's economic policy agenda. And this afternoon, like you said, he blasted the court and said the fight for tariffs wasn't over.
The Supreme Court rejected the Trump administration's request to freeze billions of dollars in funds, foreign aid, and tariff-related funds that lower courts had ordered released. That rejection is significant for a specific reason. The administration had been trying to hold those funds to keep them under executive control rather than releasing them as lower courts had ordered. And the Supreme Court said no. Release funds cannot simply be held by executive order when courts have determined they must be released. The administration does not get to unilaterally freeze money that courts have determined must flow according to law. That specific holding that the executive cannot simply freeze funds in defiance of court orders is a direct limit on executive economic power that cuts against one of the core strategies Trump had been using to assert control over federal financial flows. And when you combine that with the broader tariff ruling that we covered in earlier videos, the Learning Resources verse, Trump decision that struck down the IEEPA-based global tariffs, you get a picture of a court that has repeatedly said, clearly and directly, that Trump's use of executive power in the economic domain has limits that courts will enforce.
I'm ashamed of certain members of the court.
An angry President Trump lashed out at the justices, turning his ire on three of the court's conservatives, Neil Gorsuch and Amy Coney Barrett, justices he put on the court, and Chief Justice John Roberts, who wrote the opinion.
They're very unpatriotic and disloyal to our Constitution.
The three joined with the court's three liberal justices to rule that the federal emergency trade law that gives presidents power to regulate imports did not authorize President Trump to impose tariffs. Said the Chief Justice, had Congress intended to convey the distinct and extraordinary power to impose tariffs, it would have done so expressly. The ruling invalidates 10% baseline tariffs on almost all global imports, as well as significantly higher tariffs of up to 50% on goods from countries like Canada, Mexico, and China. Dissenting justices, led by President Trump's third appointee, Justice Brett Kavanaugh, downplayed the ruling's impact, pointing to other, more limited laws which might justify most, if not all, of the tariffs at issue in this case.
This is not a one-off ruling. This is part of a sustained judicial response to an administration that has been testing the outer edges of executive authority across multiple domains. Now let us understand the broader pattern that this specific episode fits into, because the frozen funds ruling and Trump's reaction to it did not occur in isolation. They occur within a broader context of the Trump administration repeatedly testing the outer edges of executive, economic, and financial authority, and courts repeatedly drawing lines that the administration did not want drawn. The tariff strategy, imposing sweeping global tariffs through emergency powers, freezing funds, using financial controls as tools of both domestic economic policy and foreign policy leverage, was central to Trump's theory of presidential power in the economic domain. He believed and publicly claimed that the president has near total authority over trade and foreign economic policy, that Congress's role is limited, that international economic agreements and institutions are optional, that the president can use tariffs, sanctions, and financial controls as unilateral tools without meaningful judicial or legislative constraint. That theory of presidential economic authority is exactly what courts have been repeatedly testing and repeatedly limiting. The frozen funds ruling is one example. The Learning Resources tariff ruling is another. The Court of International Trade ruling striking down the replacement tariff is another. Each ruling draws the same basic line in a different specific context. Presidential economic authority is significant. It is not unlimited. It has statutory and constitutional boundaries that courts will enforce. Now let us talk about the specific significance of the court acting against the administration's request on funds that lower courts had already ordered released. Because the sequence, lower courts order funds released, administration tries to freeze them anyway, Supreme Court rejects the freeze, reveals something specific about the confrontation between the executive and judicial branches in the Trump era. In a functioning constitutional system, when courts order the government to do something, release funds, comply with a subpoena, stop a specific action, the expectation is that the government will comply. Not because the government agrees with the court's decision, but because the rule of law requires institutional respect for judicial authority, even from those who disagree with specific rulings. The administration's request to freeze funds that lower courts had ordered released was an attempt to maintain executive control over money in defiance of what courts had determined the law required. And the Supreme Court's rejection of that request was the court saying no. The court's orders will be respected. The administration does not get to simply ignore judicial determinations about how federal funds must be handled. That is not a complicated or controversial legal principle. It is one of the most basic elements of the rule of law. Court orders are binding on the executive branch, and executives do not have the unilateral authority to nullify judicial determinations by executive action. The Trump administration's attempt to do exactly that, and the Supreme Court's rejection of it, represents one of the clearest examples of judicial authority being asserted against executive defiance in the modern era. Now let us talk about the political significance of the court that Trump helped shape, ruling against his core policies. Because this dimension of the story is psychologically and politically significant in ways that the legal specifics alone cannot fully capture. Trump spent significant political capital on his 3 Supreme Court appointments. The confirmations of Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett were among the most consequential and most contested political events of his first term. He framed those appointments as one of his signature achievements, as the lasting legacy of his presidency that would shape American law for generations. And when those justices, or a majority that includes some of them, rule against his signature trade and economic policies, it creates a specific political and psychological dynamic. The narrative of loyalty and control that Trump applies to his human relationships, people are either loyal or they are enemies, runs directly into the constitutional reality that Supreme Court justices are lifetime appointees who owe no loyalty to any president and who are specifically designed to be independent of political pressure. The collision between Trump's transactional worldview and the constitutional independence of the justices he appointed is itself one of the defining stories of the Trump judiciary relationship. And the fury he expressed when briefed on the adverse ruling, that disgrace characterization, the vulgar language, reflects that collision in its most raw and most personal form. Let us also talk about how the tariff-related rulings fit into the broader pattern of courts checking Trump's claims of near-total executive authority. Because the frozen funds case and the IEEPA tariff ruling are part of a pattern that extends across multiple domains of presidential power. Immigration emergency orders blocked by courts, environmental regulatory rollbacks overturned, spending freezes challenged by lower courts. And now, the economic centerpiece of the second-term agenda, the sweeping global tariff strategy, struck down by the Supreme Court on the grounds that the statutory authority being claimed exceeded what the relevant law actually authorized. Each of those rulings represents a court drawing a line between what the law permits and what the administration was claiming the law permits. And taken together, they establish something specific about the constitutional landscape of this presidency. Trump's second term has been characterized by a systematic attempt to push executive authority to its outer limits across every available domain. And the courts, including the Supreme Court with 3 Trump appointees, have repeatedly responded by drawing lines at those outer limits and enforcing them. The pattern is clear. The direction of the judicial response is consistent. And the gap between Trump's claimed authority and the authority that courts have confirmed he actually holds is one of the most important institutional stories of the current moment. Now, let us talk about the political and narrative implications for Trump's dealmaker image. Because Trump's political identity is built significantly around the claim that he is a uniquely effective negotiator who can use leverage to get better deals for America than conventional politicians can achieve. The tariff strategy was central to that identity. Tariffs were the lever. The threat of economic pain was the negotiating tool. The ability to escalate or de-escalate trade pressure was the source of leverage in every negotiation with every trading partner. And when courts say you cannot impose these tariffs this way because the statutory authority does not exist, They are not just making a legal ruling. They are undermining the negotiating leverage that Trump has been presenting as the core of his economic effectiveness. A tariff threat that courts have found to be legally invalid is a significantly less credible threat than a tariff that can be enforced. Trading partners who watch American courts strip away the legal basis for the tariffs being threatened against them are recalculating their negotiating postures in ways that reduce Trump's leverage. And that reduced leverage, that practical consequence of the judicial rulings on his claimed authority, is what commentators mean when they describe the rulings as cutting through his strongman image. It is not just symbolic. It has real practical consequences for the effectiveness of the economic strategy that the image is built on. Let us also think about what Trump's reaction to the adverse rulings, the fury, the disgrace characterization, the attacks on justices as disloyal, reveals about his theory of how the Supreme Court should work. Because the specific language he uses when courts rule against him, disgrace, disloyal, attacking the courts, is not just emotional venting. It reflects a specific worldview about the relationship between the president and the judiciary. Trump's worldview appears to include the expectation that justices he appointed owe him a specific form of loyalty, that appointments create a kind of obligation to rule in ways that serve the appointing president's interest. That expectation is constitutionally wrong and professionally impossible for justices to fulfill. But it is a consistently expressed expectation that shows up in Trump's reactions to every adverse ruling from justices he appointed. Gorsuch votes against the IEEPA tariffs. Trump calls it disloyal. Kavanaugh joins a decision that limits executive economic authority. Trump expresses disappointment and anger. The pattern of treating adverse judicial decisions as personal betrayals rather than as legitimate exercises of judicial authority is itself a significant institutional story. It reveals the specific conception of the judiciary that drives Trump's relationship with the court. And it helps explain why the public attacks on judges, which Chief Justice Roberts described as dangerous, keep occurring. They are not accidental. They reflect a consistent and deeply held view that adverse judicial decisions represent disloyalty rather than law. Now let us address the foreshadowing dimension of this story, because the frozen funds and tariff rulings happened in a specific sequence in Trump's second term that connects to the broader arc of the court presidency confrontation we have been covering throughout this series. The court gave Trump his biggest individual legal victory, the immunity ruling in Trump versus United States that expanded presidential protection from criminal prosecution. And then the same court proceeded to deliver significant defeats on his economic agenda. The tariff ruling, the frozen funds decision, that combination, immunity on the criminal accountability side, constraint on the economic power side, is exactly the mixed record that legal analysts have been documenting throughout the second term. The court is not simply pro-Trump or anti-Trump. It is applying specific legal analysis to specific legal questions. And the answers it is reaching protect presidential immunity from criminal prosecution, constrain presidential statutory overreach in the economic domain, are not consistent with any simple partisan narrative. They reflect a court doing legal analysis rather than political loyalty, which is both a constitutional design working as intended and the specific outcome that Trump's transactional worldview consistently fails to anticipate. The court gave him immunity and then took away his tariff authority. And the fury at the breakfast meeting was the reaction of someone who expected loyalty and received legal independence instead. Now, let us also think about what the governor's breakfast scene reveals about how news of adverse judicial decisions reaches the executive and how that information gets processed in the current administration. The image of Trump being briefed on a major Supreme Court ruling in the middle of a formal meeting with state governors and erupting in fury in that setting is itself revealing about how the administration processes judicial setbacks. In previous administrations, adverse judicial decisions typically reach the president through a structured briefing process. White House counsel reviewing the ruling, preparing a summary, communicating it through proper channels and advising on next steps. The decision would be absorbed in a controlled context designed to allow for measured response rather than immediate public reaction. The image of Trump erupting at a governor's breakfast suggests that whatever communication structure exists for delivering adverse judicial news to this president does not consistently produce the kind of measured, controlled response that previous administrations maintained. And the public expression of that fury, which was reported by people familiar with the room, is itself a political event. Governors who witness a president erupting in anger at a Supreme Court ruling are receiving a specific message about how this administration processes judicial checks on its authority. And that message of institutional contempt, personal affront at the judiciary's refusal to be an ally, shapes how those governors understand the nature of the administration they are interacting with. Let us also talk about the broader historical context that makes this confrontation so significant. The relationship between the Supreme Court and the executive branch has always been complicated. Courts depend on the executive to enforce their rulings. The Supreme Court has no army, no police, no enforcement mechanism beyond the expectation that the executive will comply with judicial orders. And executives have sometimes tested that expectation in ways that created constitutional crisis. Andrew Jackson allegedly said of a Marshall Court decision, "John Marshall has made his ruling, now let him enforce it." Franklin Roosevelt threatened to pack the court when it kept striking down New Deal programs. Nixon famously had to be ordered by the court to hand over the tapes that ultimately led to his resignation. Each of those episodes tested the boundary between judicial authority and executive compliance. The current Trump court confrontation has elements of all of those historical precedents. The personal attacks recall Jackson's contempt for a ruling he disliked. The court-checking emergency powers echoes the New Deal battles over the scope of executive economic authority. The frozen funds decision has the direct confrontational quality of United States v. Nixon. But the current situation has one quality that distinguishes it from all of those historical precedents: the speed. All of these confrontations are happening simultaneously. Immunity ruling, tariff ruling, frozen funds decision, personal attacks, judicial pushback, all in a compressed period, all at once. All feeding into each other in ways that create a constitutional environment that feels genuinely volatile and genuinely unprecedented. And the precedents that get established through the resolution of these confrontations will shape American constitutional law for as long as any of them hold. The court's authority depends in part on the executive branch respecting and complying with its rulings. And a president who publicly attacks the justices who rule against him as disloyal sends a signal about compliance that has institutional consequences that extend beyond any individual case. The extraordinary nature of the current court-Trump confrontation, the personal attacks, the judicial pushback, the emergency orders, is itself a data point about the health of the institutional relationship between the executive and judicial branches. Now let us think about what the ruling means for the relationship between the court and public trust more broadly. Because courts derive their authority from institutional legitimacy, from the public's belief that the court is an independent institution applying law rather than politics. That legitimacy is under pressure from multiple directions simultaneously. Trump's attacks on the justices who rule against him challenge the court's legitimacy from one direction, suggesting that his rulings are politically motivated rather than legally grounded. The mixed record of the court, immunity for Trump's personal conduct, constraints on his policy agenda, generates confusion from another direction, making it harder for either side of the political spectrum to characterize the court in the simple terms that partisan narratives require. And the unprecedented public pushback from justices in speeches and interviews, unusual enough in normal times, extraordinary in the context of a direct, ongoing conflict with the sitting president, signals that the justices themselves are concerned about the institutional stakes of the current moment in ways that transcend ordinary legal disputes. The legitimacy of the court as an institution is itself at stake in this confrontation, and how it is resolved. Whether Trump's attacks on the justices erode public trust in the institution, whether the court's rulings against his agenda are seen as independent legal judgment or political resistance, whether the public maintains the basic understanding that the court is a legitimate constitutional actor, will determine the institutional health of the judiciary for years beyond this specific presidency. And one final thought before we close. The nuclear move framing in the headline is capturing something real about what it means for a president's most important economic tool to be struck down by the institution he expected to be his instrument. Nuclear, in political parlance, means decisive, unexpected, massively consequential. And the Supreme Court ruling that struck down Trump's tariff authority was all of those things for the specific economic strategy that the tariff represented. It was not expected. Trump had shaped the court in ways that led him to believe it would be more supportive. It was massively consequential for the practical operation of his trade strategy. And it was decisive in the sense that the court's ruling on statutory authority has the kind of constitutional finality that no executive branch spin can undo. But collapsing the presidency overnight is where the framing overstates. The presidency did not collapse. It was constrained. A constraint by courts is not collapse. It is the constitutional design working as intended. The nuclear move was the court asserting its authority over the boundaries of executive power in the economic domain. And the appropriate response to that assertion, the constitutional response, the one that respects the rule of law, is compliance rather than fury. Trump's choice of fury over compliance is itself one of the most revealing things about his presidency. And it is a choice whose implications continue to unfold with every subsequent ruling, every subsequent attack on courts, and every subsequent confrontation between this executive and the judicial branch that the Constitution established specifically to check executive power. The Supreme Court is doing something in this period that is worth specifically acknowledging and appreciating, even in the midst of all the confrontation and controversy. It is drawing lines, real constitutional and statutory lines, in real time under political pressure that is unlike anything the court has faced in the modern era. The frozen funds ruling said the executive cannot simply nullify court orders by freezing money. The tariff ruling said this specific use of this specific emergency power for this specific purpose exceeds statutory authority. Those are hard things to say to a sitting president who is calling you disloyal and inept for saying them. And the justices who are saying them, including the ones Trump appointed, are doing something that the constitutional system depends on them doing. They are being the independent check on executive power that the framers intended when they created lifetime tenure and salary protection for federal judges. Whether you support or oppose Trump's specific agenda on tariffs or economic policy, the existence of an independent judiciary willing to draw legal lines and enforce them is something that the constitutional order requires. And this court, for all the controversy surrounding it, is currently doing that work. The constitutional reckoning around Trump's second term is being written right now, in every ruling, in every emergency order, and every public pushback from a justice who will not be called disloyal for doing their constitutional job. The constitutional design is working as intended. Courts are checking executive power, and Trump is resisting. The collision between his transactional worldview and judicial independence is a defining story of this era, and we'll cover every chapter.